Okay, this is lecture 4. We're going to begin the lecture by talking about the rule of law. The next two lectures, this and the next one, will be about this. So, the rule of law is a set of principles or ideals that are designed to ensure that there's an orderly and just society. Those two are very important because you really can't have one without the other. You can't have order in an unjust society. In an oppressive society, you're going to have total order, right? Because anyone that deviates is going to feel the full weight of dictatorial rule or what have you. So everyone, this is the key, is treated equally under the law. Now, again, that doesn't mean fair. It just means treated equally, process-wise, substantively, under the law. And everyone is held accountable to the same laws. No one gets a pass. There are clear and fair processes for enforcing the laws. Now, what we mean by fair processes, we really mean a process that actually accomplishes what it sets out to accomplish, right? We want this, and if we get to that, then that's fair, right? If we promise something and we do it, it's fair. If we promise something and you don't want it, well, then it's not fair, right? But you've already agreed to the level of fairness in the process, okay? So, everyone's accountable to the same laws. There's a clear and fair process. Clear is important so people understand what the game is, what the rules are, so they know when they run afoul of them. If you don't know that, or they're done in secret, or someone maneuvers them and changes them at will, then how can anyone count on them? So, you can't be accountable to the laws if you don't know what they are. That's why in the United States, for example, and other places, ex post facto laws are problematic. You can't write a law after the fact and apply it to yesterday. In other words, we can't come up with a law today, right, that says you have to wear, brown shoes. And then say, well, John wasn't wearing brown shoes yesterday, so he broke the law. John's not responsible because he didn't know the brown shoes was a law. If you allow that sort of thing to exist, the ex post facto law, what you really have is you have a dictatorship. Because they can write any law today and apply it as far back as they would like when you didn't know that was law, right? And so you're accountable to the same laws. The process for enforcing the laws has to be fair. It has to be consistent. That's what we often mean by just fair, right? Consistent in this case. And what that means is no one gets a free pass. That enforcing the laws, you enforce them across all sectors of society based on whatever demographic you want, economic or otherwise, right? So that's what we're talking about here. And that there is an independent, we talked about this before, an independent judiciary. If the judiciary is politicized, it's no longer independent. And it's just doing the bidding of a political, structure of the politicians and those that have some political clout. And a key part here is that human rights are guaranteed for all. So again, everyone is treated equally under the law. Everyone is held accountable to the same laws. There are clear and fair processes for enforcing laws, like we talked about this in the previous lecture, about the process, right? Arraignment and all of that, and warrants. That's what we mean by, a fair process. And there's an independent judiciary, and human rights are guaranteed for all, because that's, at the end of the day, isn't that what we all want? We want to have rights protected so that we can live our lives, right? And know what tomorrow's going to bring in terms of what is expected of us legally. Now, look, the rule of law goes way, 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 way back. There's a very deep and seated tradition of the rule of law because human beings form societies. We said lecture 1, and so the sort of predominant question is, okay, so if we're forming this society, then what are the rules? And you need a rule of law for the reasons I've just mentioned, right? So over 200 years ago, it shouldn't come as a surprise that Alexander Hamilton, James Madison, and John Jay, they published all those essays, right? They're known as the Federalist Papers. Now, I will just tell you very quickly, those who win the battle write the history. There were also the Anti-Federalist Papers, where there was a give and take back and forth, an argument over various aspects of creating a government and the pitfalls and so on and so forth of creating a government. And so this went back and forth. But the Federalist Papers won the day because eventually, Alexander Hamilton and the others represented a new government that, helped create a new government that obviously was going to adhere to some sort of rule. So if you go back and you look at Federalist 78, if you're so inclined, you'll see that there's many direct statements about this process. So, for example, one of them is that the Constitution ought to be preferred to the statute. Statutes are things that are written by the legislative body on the state, on the federal level. So when we talk about a statute, they're being written by legislators, regulators, or those are called regulations, but you get the idea. So the Constitution ought to be preferred over the statute. So congressional statutes should fall vis-a-vis constitutional requirements that the Constitution is superior. The intention of the people to the intention of their agents. Okay, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. That people are the ones that empower, and their intent is what should be considered. That's the point. Another quote. Nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposed that the power of the people is superior to both. There it is, Federalist 78, and that's pretty clear. And it goes on to say, and that where the will of the legislature declared in its statutes stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. Not the statute, the Constitution. They ought to regulate their decisions by the fundamental laws rather than by those which are not fundamental. Fundamental laws are tied to the Constitution. That's the fundamental document. Everything is built on that. And consequently, it's what we should be adhering to. All right, so the rule of law is a principle under which all persons, institutions, and entities, right, are accountable to the laws. Again, it's a principle, several principles, obviously not just one, but principle under which all persons, institutions, Congress, the presidency, judicial branch, and entities, corporations, what have you, are accountable to laws that are publicly promulgated, laws that the public knows about, right, that have come together, equally enforced, independently adjudicated, that the court should not be politicized, and consistent with international human rights principles, like I've already said. Now think about that. Equally enforced. What does that mean? Does everybody get the same process? And if they do, what is that process like? We talked in the last lecture about there's a determination made by the prosecutor whether to move ahead and to prosecute. And we talked about, grand juries and all of that. But at the end of the day, a prosecutor is political. Oftentimes you see a prosecutor looking to rack up wins, and in hopes of maybe moving on to a higher political position. Nevertheless, equally enforced is really, really, really important. Because if it's not, which you've got is no real governance. Independently adjudicated, same thing. Consistent with international human rights principles, well, of course, right? We want people to maximize their freedoms and their liberties without infringing on those of others. So the phrase "the rule of law" has to be distinguished, right, from the phrase "a rule of law." The latter phrase, "a rule of law," is used to designate some particular legal rule, right? Like the rule against perpetuities, right? You can't punish someone forever, more or less, right? All right. Or the rule that says we have to file our taxes by a certain date. Those are rules of law. But the rule of law, and they're the article, the, right? When we say a rule, any number of rules, right? The rule is a specific. So if I say to you, go out and get the car, you have to know what car I'm talking about. It's a definitive article, right? It's like get the car, the car. If I say get a car, it could be any car. So here we're talking about the rule of law, not a rule of law, right? Not a specific rule, but the idea of the rule of law. And again, it's one of the political ideas, morality, the political morality, and it refers to the ascendancy of a law or laws such as the institutions of the legal system in a system of governance. Okay, so what does all that mean? It just means that the rule of law is an ideal, right? And it really governs our political morality. This is what we do politically. This is what's acceptable. That's consistent with that. So the procedural, and you know I'm big on process, procedure, and goals. The procedural principles concern the process by which these norms are administered. Okay, so these norms, the rule of law, has to be administered. The devil's in the details, and the misuse is in the execution, the misuse of a rule. And the institutions like courts and an independent judiciary that their administration requires. You need to have norms, things that are expected, things that occur in a very specific way and are anticipated to continue in that way. And again, the independent judiciary. I can't emphasize this enough. It's really important. If you don't have an independent judiciary, you don't have a judiciary. If they're not independent of the political process, if you politicize the judicial branch, right, what you've done is you've vacated any of those values, the process. More importantly, what you've done is you've removed one of the typical divisions of governance, the executive, the legislative, and the judicial. So by politicizing it, you've moved the judiciary out of their particular responsibility, and have just made them adherents of the political structure. It is the worst thing. I can't emphasize it enough. The worst thing you can do is to politicize the judiciary. Any politician that does that should be held to account. Because once you politicize the judiciary, I'm not saying you can't criticize it. I'm not saying you can take issue with it. But when you begin to minimize it in some way and control it politically, now we've got a real problem. Okay? I hope you're all getting that, because that's really key here. And you don't have to look very far to see this going on pretty much all the time. There's always a desire to sort of control. That's the nature of those that are political beings, right? All right. The rule of law also comprises certain substantive ideals. These are ideals that have some substance to them, right? All right. Like a presumption of liberty. A rule of law really assumes that if there's a rule, it constrains behavior, right? And if it constrains behavior, you must be free to act in the way of that constrained behavior. So what does that mean? It means that there's, not a rule, but the rule of law says that, one of the things it holds is that there's this idea of liberty. If there's no liberty, what's the point of having the rule of law, right? What's really the point of having a rule of law, any of it? Because basically, if there's no liberty, there's no point. Okay, so why is that? Because I said this before, your freedoms have to end where mine begin. We are both, you and I, we both have the liberty of free human beings, right? All the attendant liberties. But they're going to come into conflict. And so you need some body or something, the judiciary, to resolve those conflicts. So if we both have a liberty and those liberties come into conflict, right? As you pursue yours, I pursue mine, there's a conflict. This is where the courts come in. They resolve those conflicts. I don't care if it's civil law, criminal law, there's a conflict, and it gets resolved, right? So the idea here is that liberty, life, liberty, and the pursuit of happiness. Again, I've said it before. You're gonna plagiarize John Locke. You change a word or two, but it was life, liberty, and property. Now, why is property important? The ability to acquire something and hold it as yours, and that you are protected under law from anyone taking that from you, right? Then you're truly liberated, right? I can go own that, and it's mine. I can possess it. Now, that's not greed. For example, I control my labor. I get paid for my labor. That's the exchange. And these are all laborers, regardless of what level they're at. You get compensated. I have a right to that compensation. You can't say at the end of a week, a month, a year, the money you're going to get for giving us your labor, we thank you for giving your labor to us, but we're going to give your money to the boss's relative. You're not getting paid. There's an exchange. People don't think of it that way, but your salary is an exchange for your labor, whatever that labor may be. And you have a property right to it. I think people think when you say property rights, you're talking about land or homes, that sort of thing. No, it's more expansive than that. It's something that you can possess that is yours, right? A welfare check, whatever it may be, it's yours to possess. And that's important. Why? Because we put ourselves into things, right? We give over our labor to things, regardless of, what it may be. And we look for something back because we gave something. And that's reasonable and appropriate, and it's a fundamental right. Okay? If you're a lion and you get an antelope, it's your kill, you have a right to it, right? I know it sounds odd, but it's true. You have rights to things, and property is very important. So I don't want you to think in a very narrow way, well, property is someone owns a home. No, it's anything that you have a legitimate claim to possess, right? You can't possess other people, obviously, but you get the point. All right, so this idea of liberal political morality, right? The rule of law is one ideal of many ideas and values that dominate this idea of liberal political morality. Others, in order for it to be a morality, right, to be moral, others include democracy, human rights, social justice, and economic freedom. All those things are important. We touched on the economics of this. I don't want to go too deeply into it because it's beyond the scope of the course. But what I do want to say is that when we think of monopolies, they corrupt that whole process of property. Why? They're taking your hard-earned money and charging you more than the open market would allow them to charge, because they've now basically moved everybody else out of the market. So it's a corruption, what they call in economics inefficiency, in the supply and demand relationship. So economic freedom is absolutely critical. Why? Because that's what most of us are working for, right? Some sort of economic betterment, which gives us the freedom and flexibility to pursue the things we'd like to pursue. So the rule of law, as you can see, is critical to a functioning society. You can't have a government, you can't have people in a government unless you've got, some structure for protecting, right? When all these companies went over to China because they could get cheap labor, one of the things they made the Chinese government adhere to, otherwise they would pull their corporations and the like, was the rule of law. You can't take our property, right? You can't exercise any right you may have over our property without due process, right? For example, in the United States and elsewhere, Um, you know, there's a concept, eminent domain. And what eminent domain is all about is that the government really owns everything for the people. Now, that sounds very Marxian and so on, but it's not. And here's why. If the government wants to exercise its right of eminent domain, then the government has to fairly compensate you for what the property they're taking from you. So, if the government decides they want to build a road, but your house is in the way, they have the right to exercise eminent domain and buy your house, but they have to buy it for fair market value. And if they don't, or they try not to, you can take them to court, and the court will decide and say, you can't give this person $200,000 when this house in the open market is worth $500,000. You have to fairly compensate them, right? That's an important concept. The right of eminent domain is really important. And rights can be established from just exercising them. So let me give you an example of that. This is actually a true story. In Manhattan, there was this open, really block, a square block, where nothing was there. And it was left with nothing there for like 30 years. So there was a guy that owned a concession stand on the other side of this block of land, this one square block that nothing was on. And he used to walk across that all the time to get to his stand, selling hot dogs or something, I forget what. But he would walk across. Now, one day he shows up and there's a fence around it all, and there are construction going on. And he asks, what's going on here? And he said, well, the land's been sold, and we're building an office building here, or whatever it was. I forget the particular, whether it was an office building or whatever. And the guy says, wait a minute, you don't understand. My kiosk is right over there, and I always walk across this to get to my kiosk. And they say, well, I'm sorry, but, we're building, and, you're not allowed on the property. So he sues. The short of the long is, eventually, they have to accommodate him because he created a right by exercising that right every day. Rights have to be exercised or they could be lost. So the court said, you've got to compensate this person so much. They offered all kinds of things. We'll restructure the building architecturally, so there's a breezeway. He said, I like the sunshine. Okay, we'll have a car pick you up and drive you around every day, the building. No, I like to walk. Well, eventually they just said, how much do you want? And they paid him off. Now, there's also a thing called adverse possession. That's another example of this. Suppose you have a home and you go on vacation. You get a promotion, and for 2-3 years, whatever it is, you're going to be over in Europe. And so, you close up your house and you make the move, right? And you're over there in Europe, and someone comes along and notices the house is empty. So they go into the house. Basically, they break into the house. And they say, look, no one's here, and I could use a home. So they start fixing the place up, cleaning it out, fixing it up, being friendly with the neighbors. Hey, Bob, cutting the lawn, how you doing? After all, oh, yeah, I'm over here now. Name is Carl. This is the house. Come over for dinner. 3 years, this person is establishing a relationship, and most importantly, they're paying the property taxes. Now, you come back, and there's a person living in your house. Does that person have a right? Now, in New York, I think it's 10 years for adverse possession. You have to be in possession of something for 10 years to claim a right to it. But adverse, and of course, the state only cares that someone's paying the property taxes, but the right must be protected, right? If it's not, you can lose it. You exercise it or you lose it. So why would that be? In order to have a claim, whatever that claim might be, you have to demonstrate some right to make that claim. And so the way we look at this is, well, it couldn't have been that important, although importance doesn't come into play, but you didn't do anything. You didn't post the property. That's why things get posted. you'll drive in the country somewhere and you'll see nothing but woods, and you'll see a thing that says posted, private property, do not enter. And as far as you can see, all it is trees. So why is that the case? Because someone can go on that property, and it's not just one sign, it's posted. Someone can go on that property and say, this is nice woods here. I'm going to chop down some of these trees and build a little log cabin for myself. Well, it's posted. That person is what? Establishing and exerting the right. And so you can't just do that. You just can't go in and do that. All right, so it's important to keep that in mind. So the rule there is very straightforward. You have a right, you have to exercise it, right? If you don't exercise the right, you could lose the right. So the most important demand then of the rule of law is that people in positions of authority, which is what we really worry about, should exercise their power within a constraining framework of well-established public norms rather than in an arbitrary or ad hoc or purely discretionary manner on the basis of their own preferences or ideology. So let me make this clear as a fly flies around here. Let me make this clear. And the most important thing here is there's got to be a framework. And that framework has got to be well established so people know what it is, and it's based on those public norms, rather than being arbitrary. You just can't make up rules as you go along and change them. Right? There's got to be a process for that. And it can't be purely discretionary. You can't leave it up to someone to decide what the rule is when they think the rule is changed or they should change the rule. It doesn't work that way. That's why if they change a rule, they'll grandfather people in and say, okay, if you were here, this is the ex post facto stuff. If you were here before, we're not going to change that because you grandfathered in, right? Because we can't go back and change it. All right. So, and it can't be based on their ideology. Okay, so the government has to operate within a framework. Now, why is that? Because the framework means that one has access to the government and to the structure. The framework also tells the body, whether it's a legislative body or a regulatory body, that these are the guidelines, that you have to stay between these rails. That's the way it is, right? So, but the rule of law is not just about the government. Here's where it comes. You have to exercise it as individuals. It requires that citizens also should respect and comply with legal norms, right? Even when they disagree with them. That's so critical. I want things to be a certain way, and the court just said they're not that way. Okay, I'm going to fight next battle, but I have to accept that that's what the court said. If you don't do that, if you refuse to accept the court or any part of that process, not just simply disagree with them, but not accept it, then your interests are in conflict with others, right? You have to accept those legal determinations. And if you don't accept the rights and duties of those legal determinations, then there's no law. No one's cooperating. And you're right back to the original position where everyone is at everyone else and there's no real structure. No one, you've heard this expression, right? No one is above the law. No one. That means the politically powerful, that means the elites, that means the media, that means the dog catcher in town. No one is above the law, because as soon as you allow some to be treated differently or be above the law, what you have is really no law. Because remember, the important thing is that the law be clear, precise, and executed in a way and in a manner, right, that everyone knows or has access to know, and everyone in the process is treated equally, right? I'm no better than you. Even though I may be wealthy or politically connected, that shouldn't matter. We see too little of that historically over time, and even in a democracy like the United States, we see that breaking down all the time, and it's a fight to keep it intact. And it's why Benjamin Franklin, when leaving the Constitutional Convention or Convention Hall, walked out, and there's that famous, exchange between a woman and Ben Franklin, and she says to Ben Franklin, "So what is it, Dr. Franklin? What kind of government do we have?" And his response is, "A republic, if you can keep it." There it is, if you can keep it. Because all these forces don't want that. They want control. They want power over people, because it puts them in a position where they can control their own destiny at the expense of you controlling yours. It's a reasonable assumption that all those that hold political office are either corrupt, corruptible, right, and will be corrupt. Power corrupts, and there's no doubt about that. And without the checks and balances, without respecting the structure as it is, you're going to have an elite class that just beats down everybody else, that just controls everybody else, right? All right. So keep in mind that it has to be the same for everyone. No one is above the law, and everyone has access, and this is key, to the protections of the law. Your day in court. Everyone has a right to have access to the court system and not be denied that. Now, the requirement of access is particularly important in two ways. First, law should be epistemically accessible. And what does that mean? In a manner that pertains to knowledge. People should know what the law is, in clear terms. And basically, again, it's a body of norms, right? Promulgated as public knowledge, right, to make known. So people can study it, internalize it, figure out what it requires of them, and use it as a framework for their plans and expectations and for settling their disputes with others. That's first and foremost, right? The requirement of access, right, is important because people need to know what the law is. And they should have access to that. Second, legal institutions and their procedures should be available to ordinary people to uphold their rights, settle their disputes, and protect them against abuses of public and private power. This is the importance of it. In turn, this requires independence of the judiciary. Again, this will come up again and again and again. And I think you understand why. The accountability of government officials, the transparency of public business, and the integrity of the legal procedures. Historically, all those in power have sought to corrupt this idea because it gives them more power if they can accomplish it. And people want power, right? Survival of the fittest. They want more resources for the people that they love and care about than you. And the system says, no, that's not the standard. Since you're powerful, you get more. That's not the standard. The standard is you have power. The people have given it to you. You do their bidding. And everyone gets treated fairly. So the rule of law is a working political idea. As much the property of ordinary citizens, lawyers, activists, and politicians as the jurists and philosophers who study it. The rule of law is a working political idea. What we mean by that is that you have to constantly reevaluate, alter. There's not one rule and then it just sits there, right? Things change. And the laws have to change in accordance with those societal changes and the like as we evolve. Legal philosophers tend to emphasize what? Formal elements of the rule of law, such as the rule by general norms rather than particular decrees. What are the norms? Rule by norms laid down in advance rather than by retrospective enactments, right? Retrospective enactments would be inconsistent, right? Ex post facto laws. Rule by norms that are made public. People have to know what it is. I need to know the rules so I don't run afoul of it, right? So that means it's not hidden away in some administrative cavern somewhere in the government where the average person doesn't know. So a rule by clear and determinate legal norms, right? Norms whose meaning is not so vague or contestable to leave most people subject to them at their mercy of official discretion, right? Okay, so think about this again. Norms. Okay, procedure. Equality in the process over and over again, and no discretion, right? If you're at the mercy of official discretion, they can change the rules all they want in your particular case and do what they will with you, in which case you don't have a free society, right? And that's obviously not what we want, right? We want to be free. We want to have all the liberties and rights of each other to pursue our own ends within the means and the structure of the rule of law to improve our lives for ourselves. That's a simple idea, right? So the rule of law, right? You call for the rule of law. They often have in mind the absence of corruption, which is never going to happen. The independence of the judiciary. There'll always be pressure for them not to be independent, and a presumption in favor of liberty. The devil's in the definition. What is liberty, right? What rights do you have? Things have been turned on their ear so much recently that we've lost our way because we've lost control over the fundamentals. We've lost sight of the need for independent judiciary. We've lost sight of the rule of law. We've lost sight of the power structure and the discretion that's been handed to some people that they've exercised freely and with no concern. So a law, a rule of law with, the rule of men, right? A man may be a safer ruler than the written law, but not safer than the customary law. In other words, there's custom, and we come to accept that as real. We come to accept that as a sort of the rules of the game, if you will, right? And part of that is this idea of continual debate about the relation between law and the mechanisms of government. Look, if you're afraid to speak your mind, or if you've been oppressed so you can't speak your mind, then you don't have a free society. We should be able to disagree, be on polar opposite sides of an issue, and still respect each other's right to have that position, rather than beating someone down and saying, you have done X, Y, and Z, and that's beyond the pale, and you can't think that, and you can't say that, because if you do, right, then you are violating a principle of some sort, and you get cast into a wide net of people they disagree with. No one has the right to shut you up. There's a line where your right to express yourself has to end where another has the right to express themselves, right? You can disagree with family and friends. You can disagree with me. That's fine. But you better be able to back it up with facts, or at least well-reasoned arguments, right? Because that's what makes it viable as an argument. So we need some official discretion, right? But it can't be much, because that becomes incompatible with the rule of law, right? So it comes down to authority. You've got the authority to do X, Y, or Z. You oversee X, Y, or Z, but you have to enforce the rules equally across the board, right, for everyone. So the rule of law in the courts is obviously, what the court says it is, how they interpret the rule. But keep in mind, again, the rule itself has to have certain elements to it, right? Has to be clear, has to be general public knowledge, has to be executed and applied universally to everyone with no exceptions, right? And it has to take into account the nature and the structure of the society and the people who signed on to this particular rule or what have you. So I don't want to cause anyone to go into a tailspin here, but let's take a second with Aristotle. The work of Aristotle and this idea of the rule of law is still influential. It's still moves the ball in a certain direction. So the idea here is that the rule of law depends not only on the type of law, right, but also the type of regime that enacted the administration and administered the law in question. In other words, it's not just the law as written, it's how it gets executed. The devil's in the details. right? There's always interpretation of authority. Does someone have the authority to do this or not? And there's some cases that have gone to court, even recently, where the court had to make a decision. Does this particular, administrative area have a right to execute in this particular area, right? And the court has to look and see what the mandate is. When they brought this together, this particular administrative office or whatever, or in a cabinet position, secretary or something or other, is this within their official capacity to be making decisions about? Now, look, laws should be made after what? Long consideration, right? Decisions in courts give short notice. So that tends to make, in other words, we can deliberate over legislation constantly, hold all kinds of conferences, meetings, public square stuff, debates in the Congress. But the court, when it's looking at this, takes a very short period of time, relatively speaking, to say that they've satisfied the claims of justice, right? Okay. All right. So if we look at Aristotle's discussion of general desirability of rules and his treatment, they continue, of those rules, they continue to influence modern jurisprudence. And I can't imagine that they will fade because they're fundamental. John Locke, who I've mentioned several times in his two treatises of government, emphasized the importance of governance through, here we go, open quote, established standing laws promulgated and known to the people. This is the fundamental thing, that basically governance requires rules, laws, and that those laws have to be long-standing and they have to be known to the people. If the people don't know the rules, they can't follow the rules. It's really that simple. Okay, so something is arbitrary, right, because it is extemporary, right, which means there is no notice of it, right? The ruler just figures out as he goes along, this is what we want. It is the arbitrary nature of the unpredictable, not knowing what you can rely on, being subject, right, to the will of others without knowing what exactly is expected of you. So in Locke's story, one of the things that people wanted to get away from in the state of nature was being subject to others' incalculable opinions, even when those others were thinking as hard and rigorously as they could about natural law. All right, so you're having a relationship with someone, and they never tell you what's on their mind. And then one day they tell you, we have to end this relationship. And you say, wow, why? And then they give you several reasons, none of which they ever mentioned. Well, I like this and you never do it. I didn't know you liked that. Well, how could you not know? Well, how could I know? Right? There's a poem by Robert Frost, which I'm about to destroy. But the fundamental idea is this. It ends with something like this. And so it is with children that play at hide and seek, to God afar, those who hide themselves too well away must stand up and tell us where they are. You cannot expect others to just know what a rule is, or what you need, or what you'd like to eat, anything without expressing it. Internally kept ideas, internally kept laws that people don't know about, they can't be responsible for following or adhering to because they don't know they exist, right? All right. So the whole point here, moving from a state of nature, which is where we all begin, right? What rights do we have just as living beings, right? Like the right to survive, the right to eat, the right to procreate. Those are the rights that are given to us by the very nature that we possess. So moving from a state of nature, right, to a situation of positive law, you introduce some predictability into this picture. right? And that ability, the predictability of it, is critical, um, again, to understanding what the rules are. So Montesquieu, right? His work on the rule of law is best known in connection with his insistence of the separation of powers, particularly the separation of judicial power from executive and legislative authority. The judiciary has to be able to do its work as the mouthpiece of the laws without being distracted from fresh decisions, right, made in the course of its considerations by legislators and policymakers. So what does that all mean? You need to have separation, and part of it is to have their own processes. And the courts have to act on what the law is and what exists at the time they're looking at the case. Now there is a bit of an exception to that. If the court is looking at a case and the Congress or the legislative body now changes the rule, and the court says, well, there's no point in moving forward because the rule's been changed, and so we have to, there's going to be no trial. There's going to be no consideration legally. So let me ask you a question. So let's just say it's illegal today to possess marijuana. Just keep it simple. Okay, and so you get caught and you go into court, but then say New York State then legalizes marijuana. Now you've got an interesting situation because the nature of that is positive. In other words, we're taking this particular consequence and we're saying it's no longer consequential. That is to say, well, we don't care if you're smoking pot. So do you put a person in prison and say, well, I don't care that that's the law now. You broke the law yesterday and you knew that was the law and you broke it willfully, so we're going to punish you. Now, that seems odd because what society has decided is this is not worth punishing anyone for. So one would think that would carry forward to the present matter, right? So there's a lot of discussion about exactly how the law should work and the like. So we have to keep an eye on, not just the letter of the law, but the spirit of the law. Look, you can write the words of a statute out, but what's the intent of it, right? What is the purpose of it? Because you have to satisfy the purpose, so why did you write the law? So, for example, simple thing, not really a law, but administrative thing. So lights, there are lights as you're driving, and you stop at a red light, and then people can cross. Well, if the idea there, right, the spirit of that is safety, right? It's safety. Now, the way it's structured is there are lights. There's a light system. And most people don't know that the federal law determines how long a particular light has to last. Green light, right, is not as important, and a red light's not as important. What's important is that yellow light. Now, why is that? Because we know green means go and red means stop. But what does yellow mean? It's on its way from go to stop. And so people get an expectation after a while of how long the yellow lights last. So they now know the yellow light is, I'll just say it's 3 seconds, 4 seconds, whatever it is. They can then make a decision about whether they're going to continue on, or they're going to slow down and stop. If they change how long a yellow light lasts, which New York was found guilty of doing, especially down in Queens, if they change it just by a second, someone says, well, I've got 4 seconds. All of a sudden, whoa, I'm under the light, and it just turned as I went under it. Now I violated the law. Well, there's a perfect example. I mean, it's an insignificant example, but there's a perfect example of people becoming accustomed to something, understanding what it means, and then acting accordingly, but then someone changes it. And people are unaware that it was changed. They don't know. They didn't make an announcement saying, by the way, everyone in New York, you should know that the yellow lights that are supposed to last 4 seconds, we've now made them last 3 seconds. And the purpose is that people were confused. It took too long for the light to change. So we want people to stop, to slow down when they see the yellow light, knowing it's only 3 seconds long. Okay, we can go along with that. They made an announcement. We understand why they did it. It makes sense, and everyone is subject to it. But to just change it and not let people know, that's problematic, right? All right. So a failure of the rule of law, right, in regards to all of this, is likely to lead to impoverishment of the economy. This is Montesquieu again, right? As expectations collapse and owners' incentives for production enterprise are undermined. We need the rules. We need to know what we can do. Now, I understand we all try and bend the rules a little bit, right? Look, where taxes are concerned, tax avoidance is legal. You can try to avoid paying all the taxes you can based on tax law, right? We have no problem with you trying to avoid taxes, right? So what's the problem? It's evasion. I'm not going to tell you about this money, and I'm going to keep it and not pay taxes on it. That's problematic. You can't evade. You could avoid. Now, it seems like an insignificant thing, but it's not. We write tax law, and those that want to pay less taxes, which we all should want to do, look at the law and say, I'm allowed to do this under the law, so I'm going to go ahead and do it. And then I can avoid paying taxes on that. I'm not evading taxes. I'm avoiding them. I'm avoiding them legally because you give me the statute and the right to exercise this particular provision, and it saves me taxes. I should be allowed to do that. I'm not making any arguments about, well, wealthy people write laws and everyone else sort of suffers. That's all well and good. But the point is that there's tax law. And that law says that you can basically write this off and write that off, but you can't evade. Tax evasion, where you're making money and you're not claiming it, that's a problem. You make money and find ways not to have to pay taxes on it based on statute, no problem. All right, so look, officials are more often than not treated differently in the law than ordinary citizens, right? Now, there's two things here. One is that they're just not having to pay, they're not having to have the same standard. But also, and this is where it gets messy, you have to allow legislators, for example, to be exempt from certain things. Like, for example, they can't be constitutionally arrested on the way to a session, right? Because that could corrupt the process. We have no reason to sort of take this person that's on their way to vote, right, and take them into custody so they can't vote. That's a corruption that's not allowed. So even if you want to arrest them, it's something that really can't be done if they're on their way, because that's it. Okay, so also, so they need extra powers, but think about this, and Congress gave themselves this right. Because they're in committee and they need to have people talk about the economy, that when they call in people who know about the market and what's going on in the market and can sort of predict, because, not exactly, with some reasonable amount of certainty of where the market's going, that means those people in Congress that are hearing that, they can now use that to invest. And what they've said is that we need to do this, and so we can't be charged with doing that, right? You can't say that we were using the information to sort of improve the likelihood of our portfolio increasing in value. They need to be able to hear it. So they're absolutely right, but we also know they're absolutely corrupting the process. But what choice do we have, right? What choice do we have? So there's going to be certain rights that we have to give to those politicians because they serve all of us. But nevertheless, they have to be held accountable for the actions that they perform in the name of the community. If you're going to do something and you say it's for the people, then we expect that that's the case, not for the betterment of you. So for the ordinary person, the rule of law generates a presumption in favor of liberty, right? We talk about presumption, right? The rule is giving us more freedom. Everything which is not expressly prohibited is permitted under the rule. We didn't say you can't do it, so you can do it. But for the state and its officials, we may want to work with the contrary assumption. The state may act only under express legal authorization. In other words, it's an important difference that if it's not expressly prohibited, you're permitted to do it. Well, with power, we want to do just the opposite. You're prohibited from doing it unless you're expressly given the right to do it. Do you see the difference? I can do it because you didn't say I can't do it. On the political side, you can't do it unless we tell you you can do it. I hope that's clear. Let me just kind of say that again. There are rules, right? And if there's no rule on us jumping up and down, then we can jump up and down. There's no rule on it. For a politician, if they want to jump up and down, they have to get our permission to jump up and down. They have to create a rule that allows them to jump up and down. So in the one case, you have to be granted the authority to act. In the other, since there's no constraint on you acting in that particular way, knock yourself out, you can act. There's the difference. When we talk about this guy named Dicey, right, and he expresses the rule of law in terms of principles. And so he says in his first principle of the rule of law, no man is punishable or can be lawfully made to suffer in body or goods, property, except for a distinct breach of law. They broke the law. Established in the ordinary legal manner. Legislation comes up, they write it, they pass it, it's law, before the ordinary courts of the land. The courts have to look at it and say, yeah, you can go ahead and do that. So we can go into this whole thing about administrative law, and even regulatory law, regulations. Keep in mind the same thing has to happen there. They have to be, responsible to and for the actions they take, and they have to be consistent with the authority given to them. Okay? Okay. There are extenuating circumstances like during times of war, where basically we give more authority, sort of blank authority to the political leaders because it's a state of war and we have to trust them to execute in a proper manner. But what about normal times? What about when there's not that case? So Hayek in 1944 made this argument that in normal times a society need not be managed but should be governed. There's a difference. Not managed but governed. Management means you control. You manage their behavior. Governing their behavior is the behavior happens, and then you structure your argument around that behavior being allowed or not being allowed according to certain rules. So managing a society is more of a socialist, sort of approach. And when we talk about governance, it's different because the power to govern comes from the people. All right? And then the people are left largely to their own devices within the framework of these general rules laid down in advance, knowable to people, and everyone's treated equally under that rule. The rules that would operate impersonally, right, to protect people one from the other, regardless of who they are. And it wouldn't be aimed at any one person. And this is the equality thing. We're not going after that person. We're not manufacturing rules to get that person. We're not, conjuring up a case to get that person. It can't be personal. You have to demonstrate that there's a reason and rationale behind it, right? Otherwise, you don't really have a democracy. What you have is, dictatorial rule, if you will. It's a kind of contradiction in terms of the few, right? All right. So predictability is key, right? If you don't have predictability, then you don't know what the outcome's going to be. You can't follow a rule unless you understand what it is. I said this several times because I can't stress the importance of it enough. And so we act in accordance with these principles and ideals. Now, there's a guy named Fuller, Lon Fuller, And here, he believed that government, in accordance with forms and procedures of law, had a distinctive value that could help close the gap of separation between positive law on the one hand and morality and justice on the other. Let me stop and explain that a bit. Government, in accordance to forms and procedures of law, distinctive value that could help close the gap of separation between positive law on the one hand and morality and justice on the other. So positive law structured and morality and what is justice on the other. The conventional wisdom of legal positivists held that laws could be impeccably drafted and even handily administered and still be hideously unjust. Right? So the devil there is in the details and how it gets executed. So on the one hand, writing the law is wonderful, but it can be really drafted incredibly well. But then again, it's how it's executed. You see this a lot when you're reading cases, that there's a lot of interpretation. A lawyer, and therefore judges, stock and trade are words. And words have to be defined, right? We said this the first lecture. So Fuller acknowledged that there was this link between legality and justice, right? That link was tentative. Okay, something is legal or not legal, and whether something is just or not just, those are not the same thing. You can have a law that's legal, but incredibly unjust. Now, what would make it unjust? It's not applied equally. It's unclear. The people didn't know about it. All the things we've already talked about. So keep in mind that that's what we're talking about. Fuller, in his book, The Morality of Law, formulated principles of what he called the inner morality of law. And this was principles requiring that laws be general, public, prospective, coherent, clear, stable, and practicable, right? And that these, he argued, were indispensable to lawmaking. Again, if it's going to be moral, the inner morality of the law is principles that require the laws to be general, meaning applying to everyone, public, people know about it, prospective, meaning moving forward, right, from that point forward, coherent, so people could understand it, clear, so that there's no confusion about how they have to behave to adhere to the law, stable, consistent over time. You just don't change laws willy-nilly like, I don't know, let's change that and get rid of it. It shouldn't be. It should be a more deliberative process than that, and practicable. It should be practical, right? And Fuller argued that these are indispensable to lawmaking, and I think the inner morality of law is exactly what these directly speak to, right? A law can't be moral if it is not public, not prospective, not coherent, not clear, not stable, and not practicable. How is it moral? Remember the definition on moral, and you'll be able to piece that together. So you should go back and maybe look at that. All right. So Fuller's done a lot of work on this. Now I'll talk about the rule of law and rule by law. This is really important. The rule of law is supposed to lift above politics, right? The idea is that law should stand above every powerful person and agency in the land. That's the rule of law. Rule by law, right, connotes the instrumental use of law as a tool of political power. You rule consistently with the law. The rule of law is different than the rule by law, okay? So, for example, it means that the state uses law to control its citizens, but tries never to allow law to be used to control the state, right? Rule by law connotes the instrumental use of law as a tool of political power. Oh, we're executing this law. That's how we're going to be able to do this. So the state uses law to control its citizens when we say by law, okay, as opposed to the rule of law. So rule by law is associated with the debasement of legality of authoritarian regimes, authoritative regimes. I'm having trouble pronouncing the word. In modern China, for example, is where you see this. So rule by law is associated with the debasement of legality, because you can mess with the rules and how they get applied. Again, it's the same requirements over and over again. All right. So I'm just trying to did that. Okay. All right, I'm going to leave it there, and we're going to pick up on the rule of law in the 5th lecture. The key thing is to pull out of all of this those elements which are consistent in all we've discussed. In other words, important elements like knowing what the law is, equally applied, and so on. This is essential to understanding the rule of law. It's critical in moving forward to try and understand what makes a law consistent with the rule of law and when it doesn't. Just two other things I really want you to sort of put in your head and understand how important they are. A rule of law means it's structural, that we understand, right, what are the fundamentals that must be present as we make the laws. Rule by law simply means that once they're in place, now we can go ahead and execute those laws. But again, they have to be consistent with the fundamental rule of law. So once you have the law, or you have the statute, and it's consistent with the rule of law, all those principles we talked about, then it can be executed and used, and that's rule by law. That's the first thing. The second thing is that keep in mind that rule of law goes way back. It is the fundamental means by which a society has to function in order for the citizenry, right, to behave in a manner consistent with what is good for everybody in an expansive, liberty for everyone. This is key. So the rule of law is essential to a stable society. And it is not only essential, but it is the fundamental building block of a democracy. You can't have a democracy without the rule of law. You can't have a republic without the rule of law. And anything that disturbs that rule or that structure or manipulates it is an anathema to the idea of democracy or republic. It's Franklin's, sort of warning that, if you can keep it, those in power want to distort it because it serves them. No matter, how you may interpret that, the fight is always keeping consistency in terms of what the rule is and how it is, how it's been sort of created. If there's no rule of law, there's no society. There's just dictatorship. There's just the rule of the powerful over those that do not have power, and you don't have liberty. This is all about liberty. The rule of law is what you need to preserve your rights, your liberty. It then gets used to figure out where the lines are between your exercise of your liberties and my exercise of my liberties, where those two things have to part, where my right ends and your right begins. Okay, we'll pick it up next time, and we should be able to get to the rule of law through that in the 5th lecture.